Exceptions to Restrictive Covenants in Employment Law, Part 1. I'm Richard Hiron, also known as the Hironator, and I'm an employment law solicitor. Now, this first exception would apply if your employer allows you to hold up to, but not over, 5% of the shares in a private limited company or a public company traded through a stock exchange or a stock market. Now, the significance of 5% of the shares is that it allows you, as the shareholder, to require the directors of that company to call a general meeting to discuss a particular topic. Now, it's also worth bearing in mind that an employer might actually give you the freedom to buy up to, but not over, 5% of the shares in a competitor of theirs. So that puts even more significance into that 5% of the shares point, because if you have more than 5%, you start to get better rights as a shareholder and a better interest in the successfulness of that competitor compared to your employer. So hopefully that explains one of the exceptions, but it is important to bear in mind that it is an exception that can be applied either at your employer's discretion or if a court orders your employer to essentially put that exception into the restrictive covenants. In other words, it's not a given that it will be in there. However, I hope that's helped to answer part of the question about exceptions that might arise in this kind of situation. We're going to be moving on next week to consider another completely different exception. But in the meantime, if you're finding a settlement agreement hard, bring it to Richard.